you, as the lawyers in my region say, that you can't fight City Hall, that this is an institutional problem that cannot be changed. And that's wrong, because lawyers are architects of justice. They have changed miraculously institutionalized discrimination in the past, separate but equal facilities for blacks and whites, gender discrimination when women didn't even have the right to vote. And those people who challenged the discriminatory laws in their time were faced with lynching. They were faced with the end of not just their careers, but their lives as a whole. They took much greater risks than we are calling upon you today to take when you come to assist us here in the National League of Fathers. No, my take on this is a little bit different. It's not just gender discrimination, it's a much bigger problem. It's called substantive due process. Substantive due process is the series of processes that are undertaken that make the exercise of liberty in America so burdensome, it's so constrained, that essentially eliminates that liberty interest. That's what's happening with fathers today. The Supreme Court has recognized that parenting is a constitutional right. And in fact, it's called the oldest liberty interest ever known and recognized by the United States Constitution. It has always existed. It has existed since time immemorial. And it is a right that doesn't have to be captured in the Constitution. The framers always saw it as a right that has always existed. You don't even have to define it in the Constitution, because it was a given. Much like when you go take a walk, we don't think of that as a constitutional right. We don't have to state that in any constitutional document. But now, because they've impinged on this right so much, and because they don't find it in the Constitution, you don't find abortion right there either. But they have come to abuse that right in the male context. And that's what has to be changed. It's a substantive due process problem again. That series of processes that come together that remove fathers from the lives of their children. So how does that happen? How is that occurring in our courts today? And it's happening in every state across the country. Well, it starts with the state. If you have a pen handy or you'd like to take notes, this will be a crucial part of this interview. Substantive due process. It occurs in almost every parenting case, and it needs to be raised in every parenting case. And it has to be raised in every one such that at some point in time, someone, God willing, will get such a case to the United States Supreme Court. We at National League of Fathers aim to do exactly that, and that's why we are talking to you today. The state begins in any parenting case by taking control of the children, even though there's been no hearing. They do this through this thing called the parents patriarch doctrine. The idea that the state is the parent of all children and all beings that come within their jurisdiction. It's a faulty premise. It goes back to feudal days when we used to have kingdoms, and it has no place in America today. It may play a role if a child is seriously abused, a child is abandoned, in areas where a child is neglected. But that's not the case with most parents. Parents are presumed to be fit at the outset of every parenting case. They may not get along. Perhaps they shouldn't live together. It does not mean that the state has given a wholesale, arbitrary right to take control of those children, place them above the parents, both of them, they do it to both, and then say that you must fight. You must now engage in a contest over who will be this arbitrarily named custodial parent. No reason for that. In presumptively fit cases, which are the vast majority of them, two parents come into a courtroom, they're supposed to be treated equal in the eyes of the law, but they are not. The state seizes the children, says, I am now in control because you've gotten jurisdiction here, you've come into my court, judges say that, my court, you've come into my court now, you've asked me to make a ruling on your case, and although you're supposed to be equal in the eyes of the law, we don't want to make you equal. We are going to ask that one parent take a superior role, the next parent will be the subclass parent, and that's the way that parent will pretty much remain for the rest of his, I'll say his, because it's mostly men, his life. So when you come into court as a father, you are already not equal in the eyes of the law, you are a subclass parent. So the state takes the first control, and they say, we have to create a custodial, non-custodial parent now. Even cooperating parents that are eventually forced to engage in this contest. The contest itself makes them enemies, and it seriously damages the children, contrary to this propaganda that we hear about the best interests of the child. It's not the best interest of the child any longer. It may have been at one time, but it's fast becoming the best interests of money, best interests of lawyers, best interests of a vast forensic and professional bureaucracy that has taken control of our children. It is happening. We are not on top of this, and fathers need to step up to the plate. We, we have to take the courageous action to change this. We go to wars in Iraq for what we don't know sometimes. We give up our lives, and we believe it's for the right of a cause and a good country. Well, if we can do that, men, mostly men, that go and spill our guts in foreign wars, we ought to be able to do it domestically and save our relationships with our children. Because if you don't, again, this is the process. This is what, if it hasn't already happened to you, you will recognize this step-by-step process, then it will. And if you think you're out of the woods now, it may come back and burn you again. It's going to catch you. If it hasn't already, it will come and will revisit your life and make it worse and more miserable for you. So we have to join to correct the problem. The state, again, takes superior control, even though the parents didn't give them that right. The parents have simply come in and said, decide our rights as equals. The state comes in and says, no, you're going to be unequal, and we are going to make you a superior, inferior parent. And why? So that monies can transfer from the inferior parent, non-custodial, to the superior custodial parent. Then the state taxes that. Vast amounts of money and the billions of dollars are coming into state coffers through the interest earned out of their various child support collection agencies, and that interest goes to the state. They also get kickbacks in the form of federal aid. Title IV D, Social Security Act, they get money that comes in from the federal government based on the size and number of child support orders that are entered in those courts. So you have to have this structure not for the benefit of the children, but for the benefit of the state, the money-making interests of our bureaucrats and politicians. So why you won't see a shared parenting bill make it through any legislature. So again, the framework of custodial, non-custodial parent, inherently unconstitutional, doesn't apply to fundamentally, presumptively fit parents, which are the vast majority of them in America today. The mother takes number 2 status because of a thing known as primary caregiver doctrine. You've heard this before. It applies in every case. The mother raises it right away and she wins. If you don't believe that the primary caregiver doctrine is unconstitutional and gender biased, then consider the situation. We have 3 clients. These are anonymous clients that are named in our landmark lawsuits. 3 of the 6 face the following. We have 5 fathers and 1 non-custodial mother. Okay, because women are victims, or can quickly become such a victim as I'm describing to you today. So women, if you're out there and you think this is a father's thing, you become burdened by something like this, and it happens to you someday, as our non-custodial representative parent in our case has experienced. Don't come crying after the fact to us. We need your help now. Even if you're a custodial parent, this will only help the relationship that your children deserve with that father, who will then give more incentive to taking funds, earning more money, investing it for college, and the things that are necessary for your children. If you love your children, you will help this cause. Because we are not funded by any multi-billion-dollar operation. I don't take any interest off of child support, and I'm not a detractor, but a supporter of a good cause. And we are well-intentioned. So the mother, consider this again with the primary caregiver doctrine. We have 3 fathers whose children were in the second child in each of these marriages was in the womb of the mother at the time that they were having parenting problems and decided to separate. Couldn't live together. Now how does the father have any hope? How could a good father who wants to stay involved in those children's lives have any hope of having equal time with that child, or that super parent role of custodial parent, if one of the children is still in the womb? The state has an interest in that child in the womb. Father doesn't. Believe it or not, at that point, the father, whose interest only comes about legally when that child is born, does not have any interest in that one child that's coming to fruition. The state, however, does. As you know from the Roe v. Wade decisions and progeny, the state has an interest in the womb before the father does. We're kind of inverting parenting all the way around. We are taking children, putting them above their parents. We're taking the state, putting above the families. It's inverted from the way history has taught us parenting should go, at least the successful way that it has been done over many millennia. So the father becomes the third-class parent. State's number 1, mother's number 2, father's number 3. De jure discrimination through the primary caregiver doctrine. De facto discrimination, which backs that up, because 95% of these decisions go to the mother. So the primary caregiver doctrine should be declared unconstitutional. if you take that one issue all by itself, you'll get lost, because every judge can come out and try to rationalize it somehow, much like they at one time rationalized separate schools for blacks and whites. At one time that was a law in the land. For almost 100 years that was the law. Actually, longer than that if you consider slavery and everything else, the period that preceded the schools when blacks were finally allowed to go to school. But it was from 1890s until the 1950s the law of the land, separate but equal schools. It has really created a problem insofar as if you look at the primary caregiver doctrine, you try to tack it all by yourself on equal protection grounds, you're likely to fail. That's an isolated part of the greater picture that I again call substantive due process and its violations, that combination of procedures. The father, therefore, is relegated to